This is case number 21-168198. This is LBNB Funding LLC versus Bernard Dixon. For a status conference on today's date. This is regarding a complaint that was filed alleging damages in the amount of $1,218.74. This is regarding a Credit One bank is apparently where this originated. I did receive the answer that the defendant filed in this matter. Your appearance at this time, counsel.
Yes, sir. Good morning. Matthew Kuipers on behalf of the plaintiff.
All right, your P number, if you will, for the record, sir.
71348.
All right, thank you, counsel, and good morning to you, sir. I'm looking now for Bernard Dixon, living on West Alba Drive. If you're on the Zoom, please say something at this time. Mr. Dixon. All right, the record should reflect the matter set for 9:30 a.m. It's 9:57. Looking for Mr. Bernard Dixon. Counsel, have you had any contact with Mr. Dixon regarding this matter, sir?
No, Your Honor.
One moment, sir. All right, it looks like the defendant has not appeared. I do see that the court did send out a notice ordering that the defendant be here. The correct Zoom number is on that notice. The address provided by the defendant is also the address used for this notice. Given that the defendant has not appeared, the court will enter the default of the defendant at this time. And counsel, you may submit a judgment which will be entered after the expiration of 14 days.
Will do, Your Honor. Thank you, Judge.
Court now calls case number 21-64661. This is Affiliated Diagnostic versus City of Detroit. The matter is before the court. Looks like on an adjourned date of hearing. I did send the matter over for an opportunity for parties to participate in mediation on this matter on a previous date, and then reset the matter for hearing at this time. Your appearance for Affiliated Diagnostic.
Good morning, Your Honor. James Lowe on behalf of the plaintiff. My P number is 63110.
Morning to you, Mr. Lowe.
Good morning.
For the City of Detroit, your appearance, counsel.
Morning, Your Honor. Alfred Ashew, PA 2536.
And good morning to you, Mr. Ashew, as well. So let's somebody update me on this matter, if you will.
Your Honor. Oh,
Go ahead. Go ahead, Jen.
So we got a call from the mediation center. I know that the court ordered us to mediate the case. Somehow it wasn't in our calendar, but we did get a call from the mediation center, and I did appear that morning. I did try to get a hold of the City of Detroit. For some reason, I thought that it was Crystal Olmstead's case, who I have a lot of cases with. I couldn't get a hold of her that morning, but I have no problem with the City of Detroit not appearing because, like I said, it wasn't in our calendar either. I don't know if the court would be willing to resend us there. And I know Mr. Ashew, he and I spoke actually this morning, and I know that he's going to request leave to file a motion for summary disposition, which I don't have authority to agree to. And Frank, I obviously have to oppose, but my suggestion is to resend us to mediation, and he can make his claim or his request to the court, certainly.
Mr. Ashew?
Your Honor, that is correct. During the pendency of this action, we have had the opportunity to take the claimant's deposition. So we have at least two grounds to file a motion for summary disposition if the court will allow us just until Friday to do so.
All right.
And obviously I have to object to that, but that's.
All right. Yeah, and that's understandable. And I think that we're past some discovery tests. I will go ahead and allow you to file your motion. I'll set it on for here. So I'll give you the next 10 days to file your motion. The plaintiff will have 10 days thereafter to respond to the motion. And then the court will set the hearing approximately 10 days thereafter. So essentially, you're coming back first week in April. What's that date?
You do the 7th if you want. April 7th.
I'm sorry, what date?
April 7th.
Yes, April 7th, 4/7, 4/7 at 10 o'clock a.m. And again, Council, you have the first 10 days, Mr. Ashew, to file your motion. And I don't think that have to be specific with any particular dates. You guys work together and understand how this court operates. And Mr. Lowe, once he files that and serves it on, you'll have 10 days from that time to file any response that you wish to file. And then, of course, gentlemen, I will hear it on 4/7/22 at 10 o'clock a.m.
Very good, Your Honor.
All right, all right.
Thank you, Your
All
Honor.
right. I wish you well, and we'll address the issue at that time. The date.
Thank you, Your Honor.
Thank you, Your Honor.
That is adjourned for motion here. The court calls case number 21-167-990. This is Shores Financial Group LLC versus Latia Wilcoxon. The matter is before the court, set on for a status conference. I don't have a complete file on this matter, but I do have some information. Your appearance for the plaintiff in this matter, please.
Yes, Your Honor. Good morning. Tina Runyon appearing on behalf of Plaintiff Shores Financial Group. My P number is 81255.
All right, and good morning to you, Ms. Runyon. Thank you. For defendant, do I have Ms. Wilcoxon or someone representing Ms. Wilcoxon on the Zoom? Please say something at this time. Right, I'm looking for Letitia Wilcoxon, a person reportedly living on Woodmont Street in the city of Detroit. The record should reflect that the court did send out a notice of hearing for today's date with the correct Zoom notice on this particular document. It was sent out on November 30th, setting today's date as the hearing date. Madam Counsel, have you had any contact, Ms. Runyon, with Ms. Wilcoxon or any discussions along the way?
No, Your Honor, we have not heard from Ms. Wilcoxon at all.
All right, thank you, Counsel. It appears then that the defendant in this matter has failed to appear, despite the court having given notice in this regard. I do see that there is a letter that's directed to the court. That letter was dated in November. And again, the court set a hearing at that date.
Oh. I'm sorry, Your Honor. Did she file an answer?
It's a handwritten letter, and it has the case number on it, and that's likely what triggered this hearing date.
Okay. My office never received that.
Yeah, I would suspect that that was the case because it was not a document that was even filed with the court. I think it was directed to my office.
Oh,
And in short, it says, defendant writing a letter because being sued for a bed frame and frame was leased from Aaron's. Stop making payments. I purchased this bed over 6 years. I can't remember the exact amount was due after I stopped the payments, but I know for a fact that I do not owe over $1,000. The payment was made every other week. So it's not in the form of an answer, but oftentimes what happens is the court receives something that is an attempt to provide an answer. The court will set it on to see if it actually wants to defend in that. long and short of it is that at this point, the defendant has not appeared when given the opportunity to do so. So I will enter the default at this time. And I see that there was a default that was sent in on a previous day. I'm going to enter that default at this time. And I'll allow for entry of the judgment within after the expiration of 14 days. So you can submit your judgment after the expiration of 14 days. It will be entered. The default is entered today.
Thank you, Your Honor.
Thank you, Councilor. Good day to you.
You too. Bye-bye.
Court now calls case number 21-16915, strike at 175. This is Bright Financial Services versus Vincent Dysard. That's DYSARD. The matter is before the court, set on for a hearing on today's date. Hearing is to make a status conference. The court did receive the answer to a complaint in this matter, and the complaint in this matter alleges damages in excess of $5,000, $5,208.76. Are your appearance for the plaintiff in this matter, please?
Good morning, Your Honor. Robert Zelinski on behalf of plaintiff P69250.
Thank you, Mr. Zelensky, and good morning to you, sir. I'm looking now for Vincent Dysard. Say your name for the record. Let me know that you're here, sir.
Vincent Dysard.
Mr. Dysard, I've been saying Dysard and all that. I'm gonna try to stick with Dysard because you said it, but now I'm able to understand how to say it. All right, sir. So good morning to you, sir. This matter is set up as a status conference. That's because I did receive something from you that looks like an answer. I'm taking it that the plaintiff did not receive that because I received a petition for entry of default. Mr. Zaleski, did you in fact receive the answer in this matter?
Well, Judge, we were able to take a talk in a breakout room. We've come to an agreement.
Oh,
We'd like to submit a consent judgment to the court. Sorry you went through all that. Yeah, we'd like to. So I don't know if you want to set some dates or if you could adjourn this out, but we'll get one in within a couple of weeks for sure.
All right, is that about the size of this, Mr. Zard? You've got this all worked out?
Yes, sir.
All right, so what I will do is I'll simply set it over with a control date, but it seems like you've got everything worked out. So you can email that consent to me if you wish to, and I'll get it signed right away and get back to you. And you can take down this email address that will assist in that regard. That's Latifa, L-I-T.
L-A-T.
Excuse me, that's L-A-T-I.
F-A-H.
F-H.
F-A-H.
I don't know why I can't spell her name today. L-A-T-I-F-A-H, I'm sorry, sir. L-A-T-I-F-A-H .Hunter, H-U-N-T-E-R at 36360 districtcourt.org.
Got it.
All right. And Mr. Desard, I wish you well, sir. And I look forward to getting the paperwork so that you can get this thing moving forward. Good day.
Okay, thank you, sir.
Okay, thank you. Have a good day.
All right, the court is calling case number 19-155-179. This is Jefferson Capital Systems LLC versus Brandon McIntosh. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter. It looks like that judgment was entered. Tell you just a moment. On the 3rd of July, 2019, that judgment was entered by default for $645.61. The garnishment is an attempt to collect the balance of that judgment or amounts that are alleged to be due and owing. All right, your appearance for Jefferson Capital Systems, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Thank you, Mr. Weber. Good morning to you, sir. And I believe I see Brandon McIntosh. Good morning to you, sir. Are you Brandon McIntosh?
Yes, I am, sir.
All right, and good morning to you, Mr. McIntosh.
Hey, good morning to you.
I see that you filed objections to the writ of garnishment, and you specifically noted in your objection, this is fraud. This is not me. I was never served anything, nor have I ever lived at this address. So that is your basis for your objection in this matter. Is that correct, sir?
Yes.
All right, Mr. Weber, in that regard, sir.
Your Honor, unfortunately, you can't attack the underlying judgment on an objection to a tax garnishment. We did garnish the defendant's taxes last year in May of 2021 in the amount of $119. I don't believe he filed an objection at that time. We are aware of his fraud claim. My client did do a fraud investigation, but unfortunately, at this point, they're not willing to voluntarily set aside the judgment. The judgment was, we're going on 3 years almost for the judgment to be in place. They've collected money last year. They would like to continue with the judgment, and they're asking the court to deny defendant's objection.
All right, Mr. McIntosh, there are a couple of things that's going on here. One is that when you are raising the claim that you are raising, you have to challenge the entry of the judgment. What you're challenging is you're challenging the garnishment. So there's pre-judgment and then there's post-judgment. The garnishment action is a post-judgment action. It means that there's already been a finding and a determination that you owe X amount of money, so that they're collecting on that judgment. It sounds like what you want to do is, it sounds like you want to attack that judgment, and you can't do that in a post-judgment proceeding. You have to file some type of motion to attach the judgment itself or to attack it. And that's typically in the form of some type of motion for relief from judgment or motion to set aside a default judgment. It's typically something like that. But when there's a judgment in place and there is a garnishment filed on that judgment, you can really only attack the garnishment when you're dealing with the garnishment. You have to file something differently and separately to attack the judgment itself. That's why when you looked at the form, that's why it had the various provisions that it had on there. So like, if there's a judgment entered against you, one of the attacks on the garnishment issues, one of the attacks on the garnishment is that I filed bankruptcy. I have an installment plan. The funds are exempt, that kind of, those are the typical kind of attacks on garnishment. An attack on the underlying judgment is not allowed when you're doing an attack on the garnishment. So you have to file something like a motion to set aside the default judgment or a motion for relief from judgment, something along those lines, put in writing the issue that you raised regarding fraud, anything that you might have done to have the fraud investigated, and the court will take a look at that. I'm duty bound to review those kinds of things. I'm just not allowed by law to review that in the context of objections to a writ of garnishment. So go ahead.
Sir, excuse me. I did my fraud paperwork. I made a police report. I don't know anything about this. I'm getting money. I'm getting money taken out of my work checks. And that's the only reason I found out about this judgment is because I seen a garnishment taken out and I called my payroll. I was 17 years old. I wasn't even old enough to move out of my mom's house yet. So I don't know how to go about this. I didn't know anything about this.
Mr. McIntosh, can you write down my direct dial?
Yes, 1 second, please.
Okay. It's area code 248
248
458
458
0462.
0462.
Call me directly after the hearing. I'm happy to talk to you and try to work something out.
Okay. It's
Okay.
just frustrating. Like,
I understand. I read over everything you wrote. Like the judge said, I have to ask for the garnishment to be denied today, but we can talk after the hearing. Okay?
Here's what I want you to understand is that the information that I gave you is explaining to you the process to go about doing this. You've done a lot of the stuff that is necessary, but when you bring it before the court, and the only part that requires some adjustment is how you bring it before the court. And I don't expect you to know that in advance because you're not a lawyer. You wouldn't know anything about that. That's why I went through that explanation with you. Anything that I say today is not saying that you don't have a claim, that you don't have the right to address the issue that you're addressing. That's why I took the time to kind of talk to you about that. What's happening is that you're caught in that middle situation where a judgment is already in place, and so the plaintiff is allowed to move forward with the garnishment. The attack that you're bringing is on the judgment, and it probably doesn't make sense for you for that to be separated, but the law separates those events, and you've done the necessary steps like police report, underlying issues and so on and so forth. What you probably needed to do was to file a motion to set the judgment aside based upon the fraud claim. That's not in front of me right now. And that's why counsel is objecting to the court setting aside the garnishment. That's what's going on. But it seems like something went wrong here. And that's why counsel wants you to know we're going to talk about it, figure out how to get to that. That's why I took time to kind of talk to you about it. I'm not sitting here saying that, hey, you don't have any chances with this. And obviously your wages being garnished is a significant issue which nobody takes lightly. The best thing that could happen here is that the judgment that was entered was in the nature of some $600 and something, as opposed to a judgment that's $2,000 or $3,000, in which case you're dealing with this, the worst that could happen to you here. And I'm not saying that it should, but the worst that could happen to you here is $600 or $700 versus something much worse than that. How much money has been taken from you? I know this is garnishment. How much money have they taken already?
$451, I want to say.
Okay.
I think it's like $106 balance.
All right, so what I'm going to do, sir, is I'll stop the garnishment. At this point, what I'm going to do is I will release any funds withheld to the plaintiff. If it's determined that this judgment should not have been entered against you and it's ultimately set aside, then they would be required to refund your money to you. But what I'm going to do now is I'm going to suspend the garnishment regarding this matter, and then I'll set a date in the future to come back and review this. Hopefully, you guys get it worked out. If you don't, then it'll be a review date for me to take another look at this. But I'll go ahead and stop the garnishment now, simply because you're so close to paying this off, and because it seems like you might have something that you might want to bring before the court regarding potential fraud in this matter. All right, so that's going to be my determination. The objections I would have to determine at this point are invalid for the reasons that I mentioned. I will release the garnished funds to the plaintiff, but I will stop the garnishment. And Mr. McIntosh, if you will chat me an email address, I will send you a copy of the order stopping the garnishment so you can take it to your employer, and they won't take any further. They won't garnish your pay any further. You understand, sir?
Yes, I understand. Thank you, Your Honor.
All right, thank you. Counsel, anything at this?
No, thank you for your time this morning, Your Honor. I think that was a very fair ruling.
All right, thank you, sir. Thank you. I'm just going to put a control date on it. That control date is going to be March 31, 3/31/22. That's going to be 9:45 a.m. And if the parties are stuck on this, I'll take another look at things at that time.
Okay, sounds great. Thanks, Your Honor.
All right, thank you. Thank you. Good day to you, Council. Good day, Mr. McIntosh.
You
Mr.
too.
McIntosh, make sure you chat me your email address so I can get this form emailed out to you, sir.
How do I chat it to you? It's my first time doing Zoom.
All right, well, I tell you what, just give it to me and then make sure, if you get off of this, make sure you call Mr. Weber so you guys can talk.
Okay, I will. My email is my last name, first name, 21@yahoo.com. So McIntosh Brandon 21@yahoo.com.
Got it. Got it, Mr. McIntosh. Okay, we'll get that over to you right away and call Mr. Weber right away, sir.
Okay, thank you, Your Honor.
All right, good day to you.
Thank you. You as well.